There we go. All right, so welcome everybody to the November Age-Friendly Marin Forum. It's good to have you here, and we will be talking today about end-of-life planning. We call it getting your ducks in a row. You may have expected our age-friendly Fairfax leader, Jody Timms, who is a former director at Redwood in Mill Valley, and she speaks on this quite frequently in Fairfax. However, she had an emergency, and so we are so grateful to Margaret Farley to be here today, and I'll introduce her in just a second. Age-friendly Marin Forums are monthly events where we have topical speakers, and some of you have been here before, in discussions that we hope will keep our community residents and our community organizations and their staff up to date on issues on aging and opportunities, and hopefully build discussions also during these sessions. So death and dying are obviously two inescapable parts of life that are often pretty difficult to accept depending upon your situation and who you are. And so exploring the topic of our mortality and its effect on the human psyche and emotions, and even getting down to the brass tacks of what today, of the logistics of planning for the end of life, forces us to confront our fears and our lives as we've lived them. So it also forces us to confront our relationships with our friends and families. So with that, I think it's important, it's wonderful that we have Margaret Farley here, who is an elder legal counsel with 37 years experience. And she has a private practice of Farley Law Offices in San Rafael. She's a longtime San Geronimo and Marin resident. And with her experience helping others to navigate legal planning, legal defense when things go wrong or even when they go right, she can really teach us today how best to plan and to best protect ourselves, our assets, as we consider our health care, our families, our caregiving needs, and perhaps as one person asked earlier, our post-mortem digital presence, how we live on in the internet world. So while we are moving forward, please think of your questions. You might all have some specific questions that you brought today or think up, and you're welcome to put those in the chat as we go, and Patty and I will monitor that. And Margaret, I didn't ask you, but how do you prefer when you're going through topics, do you prefer to take questions related to that topic at the time or towards the end of your whole presentation? It's up to you. We like dialogue or we like presentations.
It makes more sense to me that they ask the questions when we're talking about the topic, because otherwise I might not know what they're referring to that I may have said. So
that makes
it easier if we keep on topic. And if you just alert me if I keep talking and there's a question, just to tell me there's a question, and I'll be happy to stop and address it as best I can.
Sounds like a good plan. So with that, does anybody have any questions right now? Okay, let me go to the chat. I do see something in there. Oh, yes, thank you. Patty's asking everybody to mute themselves. Okay, so with that, I'll introduce you, Margaret. I'll turn over the mic to you, and you let me know when you'd like the presentation to go up.
Okay, you can put the first slide up.
Sure.
I'm just going to introduce myself. As you just heard, my name is Margaret Farley. I'm a lawyer in San Rafael, was born and raised in San Rafael, haven't gone very far. I live in West Marin, and I work with West Marin Senior Services, helping seniors in the transition process of getting ready for their end of life. So part of what I'm going to try to talk about today is the legal side of it, but also some practical things that I think you all need to be aware of on planning for how you want to prepare for your end of life. So I have to tell you up front, because I'm a lawyer, that I'm not giving you specific legal advice, and I'm going to hit some of these topics very generally. Part of the legal side of it is introducing you to certain concepts, but I have to tell you that on the legal side of planning, it's really important that you sit down with legal counsel and make sure someone understands your very personal situation and directs and advises you on what your personal needs are, because this is not one size fits all. Some people need complicated estates. Some people don't need an estate at all. And I'm going to kind of walk through those theories so you can see whether you have an issue or not. If you can go to the next slide. So setting up an estate plan can be a very complicated thing. There's lots of pieces, and this is a silly slide to show you that there's lots of pieces, some of which you don't need and some of them you do. So that's, again, my emphasis on, it's not one size fits all. You don't need all this stuff sometimes, and you need to talk to someone. And one of the people that you can talk to as an initial resource is definitely talking to legal aid. If you have a complicated issue, they'll refer you out to attorneys. Sometimes I get cases from legal aid in this field to try to walk you through what you need. So don't think of working with a lawyer or planning your estate as being an expensive proposition, because it does not need to be expensive. And I want to emphasize that. All right, if we can go to the next slide. What I first want to say is, don't wait. It's best to do this, to think about it ahead of time, to talk to people about it, but don't wait till you're in a medical situation or a financial situation where you're going to make choices when you're in jeopardy. The sooner you do it, the better it is. You have to figure out what your intentions are. What is it that you want to do with your end of life? And what do you want to do after your end of life? So what happens with your stuff, as I like to call it, but also how you want to transition out of this life. And that's part of what the planning is all about. It's not necessarily about what happens after you're gone. It's also about planning. I'm here. This is my personal dignity. This is how I want to go out. And I don't say that facetiously. The better you plan, the more control that you have. So don't wait. You want to be in control of what happens to you. Don't wait till it's too late to do that. There are medical issues. You need to be in control of your medical situation. If you have end-of-life medical problems, you need to think way ahead of time about, do I want to age in place? Do I want to stay in my home? Do I want someone to come in and help me? Are my children or my aunts or my uncles or whoever your family is, are they going to help you? Same thing with financial control. We all want to be in control of everything, but at some point in your life, you're not going to be able to be in control. So you have to think through, how do you want that to be managed and by whom, and what controls you want to keep and what controls you're okay giving away and to whom you're willing to give them away to, which is the bigger question. And then we get to providing for whoever's in your family. What do you want to happen when you are gone? Whether it's a spouse, whether it's children, whether it's grandchildren, whether it's your best friend. Then we start talking about what happens after life. And again, you have to think about what is it that you want, because once you determine what your intent is, a lawyer or someone else can help you put that all down and put a package together for you that meets your needs, not somebody else's, but your specific needs. And then I really stress very highly, and I'm going to talk about it later, open communication. You have a family, you have your support group. If you don't communicate your wants and needs to them, it becomes a problem. It'll become a problem for you because everyone's going to insert their own ideas into what they think ought to be happening rather than your ideas, because you haven't communicated them. This is how you get family disputes. This is how you get miscommunications, and so that what you want isn't what's really happening. So open communication is really important. After you figure out what you want, you have to then communicate that, because if you don't communicate it, there's more than likely going to be problems. So I'm really a big fan of family meetings. Get out there, meet with your family, put it all on the table. It's your wishes that are important, but it's also important that everyone knows what your wishes are, because if they don't know, they're going to try to impose what they think they ought to be doing rather than what you necessarily want. If you can go to the next slide. So one of the things that I think I want to talk about more than ever, people think about wills and trusts and all these estate things. Two of the most important documents you can have are your powers of attorney, and you need two of them. These are documents that you execute, that are documents that are used during your lifetime. These are very, very important. They have no value after you're gone. And you need two of them. And there's different kinds, and I kind of want to talk through what those kinds are. I have very definite opinions about what you might need, but I don't know your individual circumstances. So the first power of attorney you need is a financial power of attorney. And there's lots of different kinds of financial powers of attorney. So you need to understand that there are different types. You need to have one drawn up that actually meets your needs, because there are lots of forms, and I would caution you, don't go and get forms off the internet. Please don't do that, because most of those forms on the internet, first of all, are not necessarily California forms, and California has some very specific protections when it comes to powers of attorney that a general form may not address. And depending on your personal circumstances, there are things contained in a power of attorney that are very specific to your needs. So you're not going to know what should or should not be in that form without a little bit of help. So the first kind of financial power of attorney is a general power of attorney, and it basically says that this person has a right to act on my behalf. So to be clear, a power of attorney is a legal document that allows a person to act on your behalf. So it's your giving power to somebody else to do things for you. That person then becomes, in the legal world, your attorney in fact. They get to act for you as if they are you, okay? So it's a document you need to think long and hard about, and you need to think long and hard about what kind it ought to be. That power of attorney could be a general power of attorney that says they can do anything that I want, that I could do at any time. But you have to think about what kind of general power it would be. I can sign a power of attorney today that goes into effect immediately. So you could give me power to act immediately. You're still around, you're still managing your own affairs, but you've given me a right to take over your affairs. I don't like powers of attorney that go into effect immediately. It can lead to fiduciary fraud. It can lead to lots and lots of problems. If you don't need immediate help, I wouldn't give someone the power to take over your financial affairs immediately unless it's needed. You can also have what's called a springing power of attorney, and that's generally what I would recommend. And basically, you set up the power of attorney and you say who you want to be in charge. You say what you want them to be in charge of, but it doesn't spring into action until something happens. And usually that something that happens is a doctor, or in my case, two doctors, say this person no longer has the capacity to manage their financial affairs. And we think about, oh, it's end of life and I have dementia. It's not necessarily that. You could be in a coma. You could have gone to Mexico and be in jail. I mean, I can come up with lots of circumstances where it is you can't manage your financial affairs. And a springing power of attorney springs into action when it's needed. And then when you get out of jail or wake up from your coma or whatever happens to you, it springs back and the power reverts back to you. So that's a document you sign today, but it's not effective today. It's not effective till whatever it is you write in there happens. And usually that's somebody says you can't manage your financial affairs. So you can comfortably sign that today and put it away, knowing that when the day comes that you need help, someone has the power to step in and help you. So that's typically what I recommend for most people, because as long as you're able to manage your financial affairs now, you don't typically need that extra help. The other type of power of attorney that can be found in a general or a limited power of attorney is something that's called durable. And a durable power of attorney, and this is something that's very important, because if you don't have what I call the magic language about a power of attorney being durable, it's not durable. And this is language that says that you want this power of attorney to continue even if you later become disabled or incapacitated. In other words, you're no longer competent to manage your affairs. If you don't have that language in there, your power of attorney ceases in the event of your incompetency or incapacity. So if you're asking me generally, what I'm going to recommend is a general power of attorney that springs into action when something happens, and that is durable. But these are all pieces that you put together, and some fit your situation and some don't. There's also a limited power of attorney where you give someone the power to do just something, like to help you sell your house, or to deal with a certain bank account, or to deal with a certain circumstance. And that's typically a limited power of attorney, is something that's a present power that you give away. I want this person to be able to go do this or do that. I will warn you that depending on what that limited power relates to, oftentimes some people won't. If you're around and you're capable, sometimes a brokerage house or a bank or a title company will say, no, I want the person, even though you have that limited power of attorney. I've run into lots of problems with that, because as long as you're competent to manage your own affairs, they want to talk to you to make sure that there's no fraud going on, no one's influencing you in a way that they shouldn't. Those are all things that a limited power of attorney sometimes can run into a problem. I see that commonly with bank accounts, like, you aren't getting to the bank as often as you used to, so you give someone a power of attorney to put money in, take money out, and sometimes it works, but sometimes the banks start getting very suspicious because they're not seeing you. So sometimes that limited power of attorney won't work. And it's the same thing with an immediate power of attorney. When you're around and you're competent, but you've given someone else power over everything that you own, sometimes that will raise lots of questions. So be aware of that. Oftentimes I tell people that if they want to do something like that, to go down to the bank with their person and tell the bank manager, this person's going to be helping. I want you to introduce them. If you have any questions, you need to call me. If anything looks suspicious, you need to call me. But I generally don't like you giving up any of your powers or rights unless you have to. I'd rather everyone control their own lives as long as they can. And I just want to say something about the powers of attorney general. There's certain areas that do or do not go into powers of attorney, certain powers that depend on your factual situation. But a little bit later, we're going to be talking about, estate planning and trust. And I think it's important when I'm talking now about these financial power of attorneys that I help you understand the difference between a power of attorney and a trustee. And it's hard to figure out where this fits in, but I'm going to talk about it right now. So when you form an estate plan and it includes a trust, everything you own becomes owned by your trust. And so you have this power of attorney that says, this person can do all sorts of stuff. If something is owned by your trust, the power of attorney does not control it. The trustee controls it. So even though you have a power of attorney that covers all of these things, if you establish a estate plan with a trust, the power of attorney does not reach to that. But you still need a power of attorney, because there's certain personal individual rights that cannot be controlled by a trustee. So simply, for example, someone's filing your taxes for you. The Franchise Tax Board and the IRS are not going to let a trustee sign your return. They need someone with a power of attorney. So just if you need help with your taxes, you ought to have a power of attorney. If you're fighting with Medicare or Social Security or Medi-Cal or SSDI or any of those governmental benefits, if you need someone to fight for you, they're going to say, where's that power of attorney? So that power of attorney fills in all these individual rights that you have. So this is probably one of the most important documents that any of us need, regardless of whether you have any assets, regardless of what you're doing. These become very important documents. The other place is insurance. You know, an insurance company is not going to deal with someone trying to help you, or if you're fighting a bill, they're going to say, where's the power of attorney? If you're dealing with an IRA or a pension, you need to have a withdrawal from your IRA account and you can't manage it for whatever reason. You're in your coma. Again, they're going to say, where's the power of attorney? That's a personal individual right. So someone has to have your power of attorney in order for them to talk to you, to talk to that person, to work with that person, to get that withdrawal or that money that you need. So public benefits, insurance, IRAs, pensions, taxes, all of those, at some point during your life, you're going to need help with. And that's why this power of attorney becomes very important, because we're all going to need help with that at some point. Someone mentioned earlier about digital devices. So there is a law in California. It's called, it's the Revised Uniform Fiduciary Access to Digital Assets Act of California, a mouthful. But basically, in that power of attorney, you can put in there that this person has the right to access and exercise authority over your digital assets. So that's really important, because someone needs to clear off your computer. Somebody needs to go into your media account. Someone has to have the right to clean up what's in the cloud on your behalf. And that's something that can, again, be contained in your power of attorney. So that's something that I always put into the power of attorney. The other thing is an ability to get into a safety deposit box. We don't want to have to go into a safety deposit box that you forgot about 10 years later and pay a lock company, $400 or $500 to get into your box that's full of papers you don't even need. So there's some other things that power of attorney can do that for me as a lawyer are very important. One of them is that they can assert the doctor-patient privilege. I'm a lawyer, so I worry about these things, who gets to talk to your doctor, who gets to talk to your lawyer. They can assert an attorney-client privilege to anything was said to your lawyer. And then finally, they can nominate a conservator. So I need to talk about that a little bit. So the way the law used to be is when the day came that you couldn't manage your affairs, someone would petition the court to be appointed legally as your conservator. And that still exists today. And that person gets appointed by the court, and then they have to give reports to the court every year, and you're monitored, and a second lawyer set up for the conservatee, and it becomes kind of an expensive process. It's there for a reason, because it provides protection. But if you have a durable power of attorney, general power of attorney, that is essentially takes the place of a conservator. That person has, if it's a well-drafted document, almost all the same powers as a conservator. So you would never need one. But if you have put in writing in California who you want to be your conservator, should a court get involved, the court must appoint that person that you have nominated. So a key piece to your power of attorney is a clause that says, in the event that someone needs to appoint a conservator for me, I want it to be this person. So that's another valuable thing that gets put into your power of attorney. So some of these personal rights that I've discussed, these are not going to be in a form. Okay, these are going to be things that you're going to need to work out with legal counsel, or there are actually some paralegals who prepare these kinds of documents. But if it's a monetary issue, again, I would go to legal aid. They have people who can help you with all of this. So that's my 2 cents on your general power of attorney. But this and the health power of attorney are the two documents that, if you do nothing else, these are the documents you really need, because they're during life protections, and that's what you want to put in place. So
are there any questions before you move on to healthcare?
Sure.
Anybody have any questions?
And I know I talk fast, and if I go too fast, just tell me.
Okay, I'm not seeing anything come up.
Okay.
feel free to raise your hands or put your question in the chat moving forward.
Okay.
Thank you,
So-
Margaret.
Good. The second power of attorney is a healthcare power of attorney, and know that these two powers of attorney cannot be combined in California. So this health one has to be a second document, and this is called all sorts of stuff. A lawyer's going to call it a healthcare power of attorney. Some people are going to call it an advanced healthcare directory. Some of it are going to call it a living will. There's 1,000 different names for this document, but essentially, legally, it's you're giving power to a second person, someone else, to make healthcare decisions only in the event that you are unable to do so. So it's something that you signed today, but it isn't valid today because you can make decisions for yourself. And it's only until a medical care practitioner, typically your primary care practitioner, determines that you can't make healthcare decisions, that they then revert to this other person. And this power of attorney is something, and I can't emphasize this enough. You need to talk to the person. You need to tell this person, I would like you to be my power of attorney. Can you do this for me? First of all, are you willing to do it for me? And can you do it for me? Because remember, if it's a child, it's a spouse, it's your best friend, this is a hard thing to do because you're in a medically compromised position. You can't make decisions for yourself, and they have to step in and try to do what they think you want. So don't give that power to someone who doesn't want it or can't do it. This is something where you have to sit down and say, I would like you to hold my health power of attorney. This is what I want to happen in the event of X happening. Can you do this for me? And a lot of people think of this as the end of the life, I'm going to pull the plug kind of thing. It's not that. It's often something well before that. And if you don't tell the person what they want, what you want, they can't do what you want, because it's not about what I want to do. It's what you told me you want me to do for you. So if you don't have that terrible discussion, which no one wants to have, you're putting this person in jeopardy of them not knowing what you want. So tell them. Tell them. I tell my clients, you can't list somebody until you tell me that you sat down and you've talked to them and they understand what you're asking them to do. And they say, yes, I can do that for you. And I will do that for you. So be very careful about the health power of attorney. This person is going to make medical decisions for you when you can. So that means approving medical treatment or disapproving medical treatment, determining where you're going to live when there's a medical issue, as well as the end of life decision. So it's not just end of life things.
We have a question from Bridget Clark when you're ready.
Sure, go right ahead.
Hi, I just wanted to, I think you might be getting into this right now, but having done a healthcare directive for a 91-year-old pre-surgery the other day and being assigned the Kaiser form that they give you was good because it makes it a conversation and easy. I just want to, give that a plug it's a good form, the way they do it. But one of the things that I didn't think about is someone brought to me is that when someone gets something like dementia, often people continue to feed them. And sometimes it's good to bring this up because it's not a specific question on these, but would you want to be fed if you were, and I don't know how you would say it, but I thought it was a good kind of conversation piece. And I had that conversation with this person because she doesn't want to be fed if she's in a demented state down the road. So I just want to bring that up.
So I have issues with the Kaiser form, but we'll talk about that in a minute. But one of the things that a good healthcare power of attorney will have in it is a nutrition clause. And that's a discussion that you have with your client, because one of the issues with a lot of these powers of attorney, such as the one for the California Medical Association or the California Hospital Association, those are pre-printed check the box forms. Kaiser has one too. And I'll talk a little bit later about this check the box post. they don't cover some of these very particular situations that a lawyer typically would discuss with you, and one of which would be nutrition. So we think about and this is sort of a tacky thing to say, but I don't really understand a better way to say it. This, I'm going to pull the plug. That's mostly what this is not about. So there's things that are in these check the box forms that are fine, but it's what they don't cover that I have issues with. And what they don't cover are some very specific things. First of all, you need to have currently you need to have in your healthcare power of attorney a right to manage medical information under HIPAA, which is the Health Insurance Portability and Accountability Act. That's the Privacy Act that says I can't give your medical information to another person. So it's very important that your healthcare power of attorney is given some of your HIPAA rights to share information, because one of the things that they need to do sometimes is bring in another specialist, move you to another facility, or get a second opinion, or share your medical records. So a lot of these check the box forms don't deal with this HIPAA right. It would be typically in an attorney drafted one. The nomination of the conservator, we talked about that in your general power of attorney or your limited power of attorney. I also include that always in my health power of attorney. Again, if you put in writing who you want that person to be, the court will appoint it. So I'm going to take every opportunity to put that in your paperwork. There's a couple things that sometimes are controversial when it comes to doctors. And one of the things that I don't like is you making decisions with a check the box form in a vacuum. You do not have a crystal ball. You're signing this document today. You don't know what your medical condition is at the time they're going to use it. So to check the box that you want or don't want something, not knowing what the circumstances are, is extremely difficult. It's different if you're in the hospital and you're on death's door and then they try to have you sign stuff. You know what the circumstances are then, but you're preparing. So you're doing it now for tomorrow. You don't know what tomorrow entails. So it's really important not to say, do not want this, I do want this in a specific way. It's better to say it in a general way. And the general way is about quality of life. Do I want nutrition? Do I want water? Do I want these things if there's no quality of life? Do I want this procedure if there's no quality of life? And it's more about what your philosophy is about how you want to end your days. But there's certain things that are in typically a legally drafted power of attorney that you're not going to see. One is the ability to make decisions on pain medication. So, doctors are limited in some ways on pain medications. They're limited on the amount of morphine they can give you. They're limited on the amount of narcotics they can give you because you could become addicted. They can't give you opiates past so many days. There's all of these things in the medical community that are there for a reason. But if the person I love is in pain, I'm going to be happy to get them out of pain, even if it's causing damage to their kidney because they're going to die anyway. If the person that I love is in pain and they might become addicted to a narcotic that's going to keep them pain-free from death, I'm not too concerned about the addiction. Okay, so these are things that you can give your health power of attorney the right to make decisions on pain medications that a doctor can't make for you. That's really important. The other thing that's really important, particularly in the county of Marin, is the ability for the person handling your power of attorney to demand an autopsy. In Marin, our coroner happens to be the sheriff. So my joke is, and believe me, this is a joke. Do you have bullet holes? No? Okay. It's important. I've had clients in facilities that have died under mysterious circumstances, and someone needs the right on your behalf to check into that. May never use the power, but if you don't give them the power, they don't have it. You need to give them the power to sign documents. One of my favorite documents is to leave the hospital against doctor's orders. Many people choose to die at home. When you've reached the point that you're being in a hospital isn't medically necessary, a lot of people want to go home. And so I want your person to have the ability to check you out against doctor's orders and take you home. I want them the ability to transfer your care if they think you're not getting proper care. I want them to have the ability to put whatever religious component, if any, in effect while you're in a medical situation. You could be a Jehovah's Witness. There's all these things, right, where you have things that you want done, that someone needs the power to do it. And these check the box medical forms don't include all of these things that have to do with your health and well-being under the guise of healthcare or medical care. So I would urge you to not use these check the box forms, to sit down with someone and have them walk through what your wants and needs are, and have that in a power of attorney in a way that addresses your concerns and addresses you specifically. I can't say that too many times. The other thing mentioned here is a POST. It's a physician order for life-sustaining treatment. It's a one-page check the box document that doctors love. And the reason they love it is the box is checked. I don't want this. I want this. I don't want this. First of all, almost all doctors and insurance companies would love you to have one of these, but you don't have to do it. Okay. None of these things are you required to do. Does it make it easier for the doctor? Yes. But are you required to do it? No. This is something that makes a lot of sense if you're seriously ill or frail. It makes sense to have it at home on your refrigerator door for emergency medical people. But generally, if you're not in that seriously ill or frail, really frail condition, to check the box as to what you want or don't want disturbs me, because again, you don't have a crystal ball, right? You're filling it out today. We don't know what tomorrow's going to be. Did you fall and break your hip, or did you have a major heart attack? Is it a major stroke or a minor stroke? But you've checked a box. So I have serious issues with this, but the doctor and all licensed medical professionals have to follow the box you checked, regardless of the circumstances. So to pick the circumstances ahead of time, to me, can put you at risk. But again, if you're terminal, seriously ill, frail, it makes sense to tell the emergency personnel whether you want to be resuscitated or not, or what means you want to use. But if you're not that way, I would say be careful with a POST, because again, it's the doctor who's following this, not the person you've chosen, not your healthcare person that you've picked out, who knows what you want, who's going to look out for you. The POST is a directive to medical professionals. So it's very different than the person you've picked. And sometimes the POST can be, say something different than your healthcare power of attorney, and that creates yet another problem if they're not consistent, because the check the box form may not meet what you've put in writing in your health power of attorney. So that's something, talk to your physician about. Physicians love it because then they don't have to go through a third party. But as a lawyer, I'm more inclined to trust the person that you've spoken to, and trust the family member. Okay, that's all I have on powers of attorney. Were there any other questions before we move on to another subject?
Bridget, is that a hand for again? Oh, Bernie, let me go to you. Bridget, let me know if you have another question. Just unmute yourself, Bernie.
Just to a close relative, basically has the power of attorney for end of life decisions. Is that correct? I mean, do you have a list of the spouse first, son, daughter?
Well, typically, if you're married, it would probably be your spouse and then a child or someone. But again, if it's a child, ask your child if they can do this. You are their parent. Sometimes those decisions are really hard. But yeah,
Yeah, but I mean,
typically,
if they can do it, then you don't need to give them a power of attorney. They just naturally have it.
no, your spouse does. But if you have more than one child, what happens when the children disagree?
Uh, I hear you. What if you only have one child?
Typically, the medical professionals will limit, they'll limit. How do I say this nicely? Okay, so typically, yes, they will look to your family members, but if you don't have the legal document, do they have to? That becomes the question. Would I say most medical practitioners would look to the family? Yes. But I've seen families having fights at the hospital over what they do or do not want to happen between the spouse, the kids, between the kids. The spouse and the kid disagree. So as a lawyer, I would want to see a legal document.
Okay.
Barbara, please, Barbara Kraus.
So it seems to me, how do you decide, even in a general context, of what you want or don't want? I mean, even for the like 5 wishes, I always feel like, how do I know whether I want music at the end or not? I mean, any advice on
How do you know? So that's where I think an attorney drafted thing, it can sometimes be very helpful. For example, my health power of attorney doesn't say I do or do not want this. They say things like, I want you to look at my quality of life based on what you have told me, what I've told you I want to happen. I want you to use your best judgment. I want you to wait a short period of time. I want you to investigate. And then I want you to do whatever makes me have a quality of life. So if that means say yes to a surgical procedure, fine. To say no, fine. To take me home, fine. But you can't plan out the medical circumstance. You just can't, because you don't know what it is. But in terms of those other things about, personal, how you want things to be, you just put that in there. I mean, I want to be flown to Ireland and my ashes, strewn. Fine, put it in there. I want, to be surrounded by my family. Fine, you can put any of that in there. But I'm talking now in terms of the medical piece, not picking things, because again, it's very difficult because you don't know what the medical circumstances are.
Thank you. That explanation of the steps really makes it clearer. Thank you.
Yeah. So this isn't, don't get me wrong, this isn't easy, but the more you do ahead of time, the more you prepare for this, the easier it is later, because you don't want to be making these decisions when you're not feeling well. You don't want to be making these decisions when the whole family is stressed. This is not the time to be having those discussions. It's just not. So I would just say be doing it all up front, doing the best you can, and then hope that it meets all the circumstances. But typically that's what you're going to get if you have help from a lawyer.
Nancy, you have a question?
Yes, I have 2 questions. One, you mentioned very briefly how a trust counteracts a power of attorney, and I suppose you're probably going to get into that maybe in your next section, but I just was curious to find out how a trust works with a power of attorney. And then the second thing is, I know this is a very broad answer depending on the size of the estate and the complexities, but what would be the approximate cost for a person to see an attorney and write up all the things you have to write up, including
Oh dear.
a will, power of attorney, etc.
Okay.
I mean, if you just wanted to just say, okay, I'm just going to do it all today. I've been putting it off for years, and I just want to get it done.
So that's a question, because just so you know, attorney's fees are not mandated by law. They're whatever the attorney charges, and they're all negotiable. So, you know, if money is an issue, again, I would start with legal aid. But I can't tell you what various attorneys charge. It's very different. Some attorneys in this field charge by the hour, and you can get hourly rates from the lowest hourly rate I've seen lately is probably $300 an hour, and up to, I got a client who charges $1,200 an hour, who's a lawyer. So yes, you don't want to go there. But then some attorneys, you know, they have it's like a package for $5,000. You get all these forms. So I can't really answer that.
Is the key to shop around, Margaret? Just to shop around with a very specific list of what you want to achieve?
Yes, well, know what you want, but also I instead of shopping around, I would ask your friends and neighbors. You know, who have they used? Who have they had a good experience with? Because I think that's how you find the good attorneys. Is someone who's had a positive experience, who's had this done. One of your friends or neighbors who's got a will, got a trust, had a good experience with someone. That's what I would put my money on. But if money's a huge concern, start with legal aid.
And I put the legal aid website in the chat for those who are
perfect.
Want to copy that down.
And then your issue about trust, we're going to get to that. That's the next section after I get through this probate avoidance. Okay. And if I don't answer your question, then come back and bring it back to my attention. Okay.
Okay. Thank you.
All right. So you hear about this all the time in California, how to avoid probate. So I want to make sure you understand what probate is. Probate is a court supervised process for transferring a deceased person's assets to their beneficiaries. So that can be done because you have a will and you file the will with the court, and the court proceeds to administer that will with the help of whoever's in charge. It can be that you died without a will. And you died in what we call intestate, and then the court goes through who the next of kin is and puts somebody in charge and processes your estate. Your estate is everything that you own. So that could be the car, it could be your library books, it could be the house, it could be your stock accounts, your bank accounts. It's whatever are your assets, that's your estate. So either there's a designated legal document, a will, or there's no will and you died intestate, and then the court will process your estate without any legal document. But someone then files a petition with the court to say, I want to be in control of dispersing whatever the assets are, whatever they may be. And you'll hear often about avoiding probate. And the reason you hear about avoiding probate is several things. First of all, it's not an inexpensive process. It takes a long time to get through the courts. I'll tell you this much, particularly now with the COVID and the like, you know, you can file a petition that's supposed to be heard in 30 days and you might get a hearing date 90 days or 120 days out. So it's time consuming. It involves the court approving things that are done. And it can become an expensive, long process. So that's why you always hear avoid probate. Well, there's lots of ways to avoid probate, and it doesn't necessarily mean having a big fancy estate plan. So that's what I want to talk to you about, because a lot of people don't need a big fancy estate plan. Don't get me wrong, I still want you to have the powers of attorney, but you may not need a big estate plan. So the first thing is a small estate. So in California, and this changes every year in, I believe, April, if you have what's called a small estate, you can collect that deceased person's assets by an affidavit, which is a form. It's a California form, and you can collect assets. Currently, if the person's assets without real property are less than $166,250, not sure why they have an uneven number, you can actually go and collect the estate and disperse it without the necessity of going to court. You have to wait 40 days, but after 40 days, you can show up with this declaration at the bank, the stock place, whatever you need to do, the DMV, and you can disperse the assets. You'd still have to be entitled to the assets. So there either has to be a will saying you're in charge or you're the next of kin under the law. But if you were like a spouse, you could just go get it. If you were the only child, you could just go get the assets with a small estate affidavit and not go through probate. So be aware of that, because you don't need a big fancy estate plan if there's not a big fancy estate. There's also another affidavit process, which is a real estate of small value. If you have real estate that's less than $55,425, don't know why that one's not even either. You can collect that real estate by affidavit. Now, we're in Marin, so, but you could have like a piece of raw land that you bought up in Shasta that you're going to build a cabin on, or you could theoretically have a piece of property that's less than that. If you did, you could collect that by affidavit. If the person that died is owed money from their employer or someone that they were doing independent work for, you could collect up to $16,625. California has no even numbers. I've come to this conclusion. And by the way, all these numbers go up every year by a little bit. The code has inflation factors in them. Sometimes they're annually, sometimes every 2 or 3 years. But so you could go collect, you know, they were a contractor and they were owed $16,000. You could go collect that by affidavit, again, not going through probate. You could have POD accounts. Those are payable on death accounts. So I have a checking account and I put your name on it saying on my death, it goes to you. That person would be able to collect it. And then the one that you hear about all the time is to have a trust, because a trust is a legal document that should not and typically does not go through probate. And that's usually one of the major selling points for a trust. But I want you to be aware of all these other things, because all of these other things, most people don't know. I'll tell you one other thing, although I don't like to talk about this too much. There's something where a spouse can file a one petition with the court. It's a spousal petition. And if you own everything in community property, and the spouse can file one petition and the court will direct it directly to them. It's going through probate, but it's usually a one-shot deal. But there are some intricacies with that. So I wouldn't put your hopes on that without actually talking to a lawyer first, because that, again, can cause some delay in an estate. Okay, so now I want to talk about trusts. Is that the next? I believe that's the next slide. Or is it's titled to real property? Okay, so there's also ways that you can hold title to real property that will avoid probate. And you have to be really careful here. I don't want to give you tax advice, not knowing the circumstances, but there are certain things, ways that you hold property where on a death, it automatically converts to another person. So if I own a piece of property in joint tenancy, holding it in joint tenancy, particularly if you hold it with joint tenancies with right of survivorship, whoever survives, if 2 people own it, whoever survives automatically inherits the property. So you can just file something with the recorder's office showing a death, and your name will go onto that property. So sometimes people own property in joint tenancy. I do not recommend that if you're married. There's a presumption, a statutory presumption in California, that if you're married, title to the property is in community property. And there's tax reasons where if you're married, you ought to own your property as community property, not joint tenancy. But there's a lot of old deeds where you've been in your house a long time and they might be in joint tenancy. If that's the case, you might consider having a new deed drawn up to put it into community property if you're married. Tenancy in common means more than one person owns it. And unlike joint tenancy, where it automatically goes to whoever's on title, Tenancy in common does not go that way. It goes by your estate. So if I own the property with you and I die, my share doesn't automatically go to you. It's whoever inherits it. That is something that you probably don't want to have your name on a deed with a spouse in tenancy in common. Wouldn't make a lot of sense. It could make sense if you have a blended marriage, and I don't want to go into all those details, but this is something you should talk to a lawyer about, is how you're holding your property. Take a look at your deed. Like I said, community property is what is presumed in California. Nowadays, most of the deeds say community property with a right of survivorship. That again is kind of like joint tenancy, where the spouse, without having to go make a spousal set aside petition, would just file something with the recorder saying my spouse died. Now take their name off the property, leave my name on it alone. So it's important to know about title to property, because that can or cannot send you potentially into probate. And there's an issue with taxes that I'm just going to tell you what the concept is, but it's really hard to tell you without knowing your circumstances. So if I own the property as community property, on the death of my spouse, the property gets stepped up in basis. And that is something that I'm going to talk about a little bit later too. This is really, really important to understand. If you bought your property for $10 and it's now worth $100, there's $90 of gain. If it gets stepped up on the decedent's death, it gets stepped up to its fair market value, which is the $100, and all that gain disappears. So that capital gain that you've been sitting on that's taxable will go away. So that's why how you own property can be very important, because it has a tax consequence. Okay, can we go on to the next one, which I think is trusts? Yes, we got there. Okay. And again, the title to your property, I would just suggest you all pull your deed and just look at it. And if you don't have a copy of your deed, it's on file with the county. I think it's like $2 a page or something to get a copy of it. So it's not really a big deal to go get it and just see what it looks like. Okay. So another way to avoid going to probate is putting all your assets into a trust. And I say a trust is setting up an entity in the eyes of the law. And I say it's like setting up a corporation. Once you do the documentation, once you set it up, once you sign the document and the trust owns something, it becomes a thing in the eyes of the law. And while you're alive, it's a grantor trust. So it's a pass-through entity, because I'm the one who set up the trust and I'm still alive. So I don't have a separate tax return. Everything just flows through to me. But once you set it up and it owns something, on the event of your death, what happens is the person in charge, who is the trustee, does whatever the trust instrument says. Unlike probate, there's no waiting time. There's no waiting for a court date. There's no 40-day period. There's no nothing. Whatever that trust says the person is supposed to do, they do. So as compared to a will, as compared to going through probate, this is something that is quicker. And the other thing is it's private. Anything you do through the courts is public record. A trust is a private instrument. Nobody gets to see it except you who drafted it and potentially beneficiaries. So whatever it is that you've done with your estate, however it is you set it up, it's a private document. And that's the thing that for trusts is something that I think is why you have a trust. Is it because it's your private affairs? It does avoid probate. Usually, though, it does cost more to set up a trust. So the process of setting up a trust is going to incur more legal fees than just having a will. But in the end, you're going to come out ahead in terms of lawyers, legal fees, and all of the rest. There's numerous different kinds of trusts, and I'm going to briefly touch on some of these so that if you hear the words, you'll at least know what they are. But the most common thing is a revocable trust. It's called a revocable inter vivos trust. It's a trust that's created during your life. Sometimes they're called living trusts. I would urge you that you'd have to be in very specific financial situations to set up an irrevocable trust, one that cannot be changed. My suggestion is always to have a revocable trust so that if your circumstances change during life, you can change your trust. And that will become important when we get towards the end of today, when I talk about, oh, I'm going to be running out of time, I think. When I talk about some of the issues coming up with taxes and changes in the tax laws, it's going to be really important to have a revocable trust. So because I'm going to run out of time, I'm going to go through these trusts very, very quickly. But part of the issue with trusts that's happening is the tax law is going to change. So some of these trusts that are listed here may or may not become obsolete very quickly. But there's something called a spousal, a spousal lifetime access trust. This is where I can take something, gifts money into a separate trust for my spouse. It takes it out of my estate to avoid potentially tax consequences, and it allows it to grow so that when it's distributed, the growth in that trust would not be taxable. Same thing with irrevocable life insurance trust. You're going to have life insurance policies that are paid into the trust. The purpose is, again, to take certain assets out of your estate for tax purposes. All of these irrevocable trusts that are listed here, in most part, you're giving up some control and for the benefit of taking assets out of your estate if you're going to end up with a taxable estate. And so a grantor retained annuity trust is the same kind of thing. You put an asset in there, you set it up for a course of years, you get annuity payments from that asset during that course of years during your lifetime, and then it reverts to your beneficiary. The gain in the asset then goes to the beneficiary tax-free. There's a personal residence trust. It's the same kind of thing. My property value is going up. I don't want to pay taxes on the increased value. So I'm going to set it into a separate trust. I'm going to have a right to live in it for a certain period of time. If I don't outlive that time, it reverts to the beneficiaries. But again, the potential increase in the value may avoid taxes to your beneficiaries, and it takes the house out of your trust, which is most people's major asset. An asset protection trust, I would just put that out there so that you're aware that that exists. You can set up a trust for a family member if we need to protect their assets. So this is someone who has creditors coming, or who maybe will have creditors coming when you leave them your estate, and you want to protect them so creditors can't get to your money or their money. This is a specific, typically irrevocable trust that you can put money into and possibly protect it from creditors, just so that you're aware that thing exists, that entity exists, and you can look into it if that's a problem. And then there's a special needs trust. This is usually can be set up by an individual, or you could set it up in your trust if there's someone in the family who has special needs in terms of a disability, or is on a public benefits, and you want to leave them money, but you don't want them to lose their public benefits. There's a trust mechanism where you can do that. That is a highly specialized area. And if you're going to do a special needs trust, I would urge you to go see someone who specializes in that. And if you need a referral, there's a gentleman in San Francisco who used to run the elder law clinic in San Francisco, who's very good at this and will not charge you an arm and a leg if you want a referral for that. Okay, next slide. I'm sorry I went through that quickly, but we're getting into more important things. Okay, practical considerations. Family meeting, sit down with whoever is your family. Talk about what you want, how you set it up so that they're aware of it and it's not a big surprise. I also say at that family meeting, if you have what I call the stuff, dad's fishing pole, grandpa's rifle, mom's wedding ring, whatever, that stuff often is what causes disputes in the family. Sit down, have a family meeting, have your family members tell you what they want. It's your decision as to who gets what, but get that out on the table so you know if they're going to be fighting over that fishing pole, because you can take care of that. Don't let your family break up over stuff. It's usually about the stuff, not the money. So I urge my clients to sit down with the family members, to ask the family members, I'm preparing my estate. Is there something you want? Please tell me. And then you can play Solomon with your stuff. I also urge you to think about giving away your stuff, whatever that may be, during life, so it's not part of your estate and can't be disputed later. But that's up to you. So I urge you to have a family meeting, to have open communication with your family. Okay, age in place. I'm a big proponent of aging in place. But part of your planning should be, do I want to age in place? Do I want to stay in my home? And can I stay in my home? And what do I need to do to make my home safe to age in place? That's part of your planning. What do you want to happen with you? Where do you want to end up? And if you want to age in place, I would urge you to start the process now. Do I need stair railings? Do I need to modify a bathroom? Do I, don't wait till you need all this stuff. Do it over time. If your plan is to age in place, fix the bathroom now. Widen the doorway in the bathroom, get a special shower, get rid of the, 50-year-old tub that you're not going to be able to get in and out of. Do that now. Have a plan to age in place. So again, talk to your family, decide what you want to do, and then put in place things that will let that happen. There are lots of community resources for seniors in Marin. Lots and lots and lots. I urge you, if you have a specific need, to reach out. I guarantee there's a nonprofit out there that will help you. And I say, don't buy medical equipment. You can get all that medical equipment for free. There's certain things you shouldn't be concerned about, because the community resources here in Marin are tremendous. So look for those community resources once you identify what you need. And I say that particularly with the age in place process. A lot of that stuff you can get, there's lots of resources for it. Look at your medical coverage. That's going to be key later in life. Do I have medical coverage in place? Talk about it. If you don't have it, think about what you're going to do. And part of that can come into long-term care, which I probably am not going to have a right to talk, not be able to talk about it, but think about aging in place, thinking about medical coverage and how you're going to get that in-home assistance that you need. Don't forget VA benefits. Please don't forget VA benefits. People think VA benefits are medical coverage. They are medical coverage and more. They have a program called Aid in Attendance where they will send you a check every month because you need help at home. People don't use their VA benefits. So if you served in the military or are the spouse of someone who served in the military, don't forget to look at your VA benefits, because it's much more than you know. And there's a gentleman at the Civic Center whose sole job is to help you get through the VA process. He's very busy, but know that there are these VA benefits out there, and don't ignore them. It's much more than medical care. For example, the VA has a hospice house in San Francisco. It's one of the nicest places I have ever seen. And that's all covered by your VA coverage. So if there's if there's military in your background, don't forget your VA benefits. There's a process where you can homestead your house. It's you file something against your house. That's to protect it from creditors. So if you're looking at big medical bills coming down the pike, you might want to homestead your house. It used to be kind of $10,000, but now it's $300,000, or the countywide median price of houses not to exceed $600,000. So essentially in Marin County, it's $600,000. You get to homestead in your house. You get to collect, you get to save $600,000 worth of your equity against any bills out there. So if we're running out of money and your house is your only asset, you ought to consider homesteading it to save some of that equity for your family.
Margaret,
Okay.
we have a question
Sure.
about, do the VA benefits, veterans benefits, extend to ex-spouses of military?
Okay, so this is kind of a complicated question, but it depends on whether the spouse had a pension. If they had a military pension, there's a potential to get some benefits. If they didn't have a military pension, to my knowledge, no. But to be absolutely certain, I'd call the VA guy at the Civic Center just to make sure, but I'm not aware of any benefits for an ex-spouse unless there's a spousal pension out there.
Okay. Thank you.
Yeah, and there's a VA office. I'm sorry, I should have pulled that for you, Sarah,
Mhm.
at the Civic Center. And that person's sole job is to assist with VA benefits. And they're quite good. They're overburdened, but very good. Okay, so the last thing here is this gifting issue. So during your lifetime, you have the ability to gift anything to anyone. Some of the gifting is taxable, some of it's not, but it's a way to decrease your estate. So you, starting January 1st, you can give any person up to $16,000 annually without a single tax consequence of that gift. So you can start giving away your assets during your life if you choose to do so. And I just urge you that if you do that, do a gift letter saying it's a gift so that you're not going to have a tax consequence on the transfer of money. But there's also this concept of the lifetime exemption that is a tax issue under gifting that I need to explain to you. There are no estate taxes in California. People call them estate taxes. People call them death taxes. Right now, there's a federal estate tax lifetime exemption of $11,700,000. So you can have an estate up to $11,700,000. You can give it to anyone you want, and there's no estate tax effect of that. And so as between a husband and wife, that's double. So you can have quite a sizable estate without an estate tax consequence. And January 1st, that goes up to $12,060,000. But I have to tell you this, and this is going to be a California problem. That law is set to sunset on January 1st, 2026. When it sunsets, the lifetime exemption will revert back to $6 million per person. The issue is houses in Marin. If you have a house in Marin, the values are astronomically going up and could affect you having a taxable estate. So it's very important to keep an eye on that. And I will tell you that the Build Back Better plan proposes that as of January 1st, to cut the lifetime exemption in half. I don't know if that'll pass. There's always proposals to change this lifetime exemption. I mean, there's always proposals, and none of them gotten through Congress. But at some point between now and 2 years from now, they're going to do something. I can't tell you what, but they're going to do something. So be aware of that, because that could affect you having a house in California if you have one. The other thing I just want to put in your head is, if you're married, this portability thing, if you don't use your lifetime exemption and you have money left over, you can give it to your spouse. So your spouse can have a bigger estate because you gave them part of your exemption. So again, if you have a house in Marin that's worth a lot of money, think about portability and talk to your lawyer or your accountant about that on a death. Okay. Medi-Cal. Ugh, I don't know if I have time for this.
You know what? I think I kind of wonder if we should go into caregiving, because we did a Medi-Cal forum a month ago.
Okay.
So
I just want to say that that's changed.
Yeah.
That's the key. So understand that Medi-Cal has just been changed, and it used to be that you couldn't have very many assets, and that's being phased out. So this whole concept of Medi-Cal planning and giving away assets and trying to be broke is changing. So that, just be aware of that. The assets test is being phased out. So you're going to be able to have Medi-Cal coverage probably in the future more readily. And the reason Medi-Cal coverage matters is that's the only coverage you ever have for long-term care if you're in a long-term care facility. And that is what drains almost everyone's estate, is if you end up in a long-term care facility and you don't qualify for a Medi-Cal bed, it can eat up whatever you have. So if you did that, all right. Well, I think, is that one more slide? Okay, so I kind of talk about this. Oh, I didn't talk about inherited IRA changes. Okay, very quickly, the law changed last year about IRAs. It used to be that you could give an IRA to a non-spouse and it just became their inherited IRA. Now, when you leave them that money, They have
Right.
to withdraw it within 10 years. And so if you leave them a large IRA, it becomes a tax consequence for your beneficiary because they have to withdraw the money within a 10-year period. As they withdraw it, it's ordinary income. So it could throw them into a new tax bracket. So you got to think about your IRAs, and you got to think about them because a lot of people are IRA heavy because that's what we were all told to do. And it's great if you're giving it to your spouse, but if you're giving it to a child or somebody else, it can cause problems now. So keep an eye on that. Property taxes, you probably know that there have been property tax changes. The one to be aware of is if you're over 55 or disabled or a wildfire victim, when you sell property and move to a new property, you can take your old tax base with you, which will help you on property taxes if you have the place that you're coming from has a low tax base. And this is not what the property is worth, what its assessed value is, and its assessed value goes up very slowly, so it's much less than its fair market value. You can take that assessed value with you, so that's pretty important. But be aware of that if you're selling a house. Just check in on whether or not you want to take your assessed value with you. Okay. Caregiving. Couple things I want to talk about there. So end of life, there's no slide for this. So end of life, we often need caregivers. And it's important for you to understand that caregivers, a lot of people say, well, I'm hiring Susie and I'm going to pay them cash. And be aware that that has risks and liabilities associated with it. You're required by law to pay them legally, which is to give them sick time, to give them some family medical leave, to take out taxes. You know, if you pay them $10, you're going to add another 16% for the taxes that withholding or paid for the state and the federal government. If you don't pay them legally and you have a problem later, it's going to be a problem for you. So it's very important when you hire caregivers in your home. I urge you to do it legally. You can set up and become their employer legally. You can use an agency. And the other problem beyond the employer-employee relationship is the insurance relationship, because if they fall on your stairs or they hurt their back, you know, you have to have proper insurance in place. And some homeowners policies have there's a standard clause in a homeowner's policy that will provide some coverage, but depending on how often this caregiver is coming, how much they're paid, how many hours they work, it may or may not be covered by your homeowner's insurance. So if you're going to have a caregiver, I urge you to do it right, and I urge you to do it legally, because it could backfire, and it could backfire in not a pleasant way for you and your beneficiaries, your family.
And Margaret, you were saying to me when I first spoke to you, and I've heard it from many others too, I've heard it from residents who did it. There's so many cases on the books, and they're increasing of caregiver fraud with families and independent adults. So
yeah, I'm
be forewarned.
A proponent of using an agency for precisely that reason. Couple things. The caregivers through the agency are given sick time, they're given vacation time, and so they tend to be, I think, happier caregivers. But also then you have a liability policy that's going to pick up if they get hurt, if things get taken, if someone tries to take advantage of you. There's another layer of protection in my mind, but it is more expensive to do it that way, and that discourages many people from doing it. But understand that having caregivers in your home is, again, it creates some problems that you should deal with ahead of time. If you want to age in place, I'm not saying don't age in place. I'm saying try to do it properly and try to plan it out ahead of time so that you have a place for them, and you've set up the proper insurance, the proper payment method, the employer-employee relationship. There's a lot of new cases coming down about this now, and they're not pretty, because if you don't comply with the labor laws, they're starting to penalize you greatly in these kind of personal attendance situations.
Mm-hmm.
Okay, I've run over. What else?
Well,
Do you have more
no,
questions?
Yeah, let's go to questions now before we close out.
Okay.
Anybody have anything that?
I wanted to remind people we had a speaker from Jewish Family and Children's Service who said that they have a service for older adults before you have a problem, so that you get set up and your history is there and your contacts are there and everything is all set up and you have like an account with them. And then when you have a need, then you're not scrambling at the last minute to do that. I thought that was a brilliant thing.
That's a great resource. They're a great resource. And if anybody wants to contact me, feel free. I'll be happy to answer your questions.
Yeah. I just want to thank you, Margaret. This was so wonderfully thorough. I imagine everyone has taken a lot of notes today, and you've given us all things to think about that maybe haven't come to us in other kind of forums like this. So gosh, we're grateful.